In the year 2016, the name Richard Huckle was on the front page of almost every Malaysian newspaper. The horrific reveal of Richard Huckle's possession of over 20,000 pornographic photographs of over 200 Malaysian children shocked the country. This immediately sparked an unprecedented series of media coverage which led to calls for improvement of existing child protection policies and legal safeguards in Malaysia. One of the active steps taken by the Malaysian government in the curtailing of sexual offences was through the legislation of the Sexual Offences Against Children Act 2017, hereinafter known as SOACA. Gazetted on the 7th of July 2017, SOACA was introduced to address the seriousness of sexual offences committed against children in Malaysia. The ultimate purpose of the proposed act was to provide for better protection for children against sexual offences and to safeguard the interests and well-being of children and to provide effective deterrence. It also requires more participation from the adults surrounding kids, giving the phrase, "it takes a village to raise a child," a whole new light. We would be discussing the various offences that are provided for in the Act, namely child sexual grooming, child pornography, and sexual offences. Thus, this presentation would discuss and evaluate the effectiveness of SOACA by making comparisons with other jurisdictions to assess the comprehensiveness of the Act and to possibly point out the potential flaws that might exist in the Act.
To start off this discussion, we will first touch on the topic of child pornography. Child pornography is governed by Sections 4 to 10 of the SOACA, with Section 4 explicitly expressing its definition. However, the term realistic found in the provision is left undefined, which gives rise to a wider scope of its interpretation. Critics have argued that this brings out the uncertainty in the law as it begs the question of what exactly is realistic. For example, can an individual be prosecuted for possessing animated cartoon characters portraying children engaging in sexual conduct, as these images do not involve a real child? It can be said that the representation of what constitutes a child under the Act is limited to a child or person appearing to be a child, which will not hinder the sexual arousal and gratification felt by perverts who, although are legally prohibited from watching actual children conduct sexually explicit acts, are legally to watch depictions of children engaging in said acts. In England and Wales, Section 62 of the Coroners and Justice Act provides that it is an offence to possess a sexual image of a child performing sexual acts, and this includes cartoons, manga images, and drawings. In 2014, a British man was jailed when he was found in possession of such images with the reasoning that it may potentially encourage child abuse. This clearly shows that the definition of what constitutes child pornography is substantially clearer as compared to Section 4 in Malaysia, which is rather inconcise. The unambiguous definition in England and Wales amounted to a higher level of certainty and transparency when judges aim to interpret the law. Furthermore, it is undeniable that this holistic approach of including animated cartoons portraying underage children performing acts which are sexual in nature as part of the definition of child pornography taken by England and Wales provides for better protection for children, which is clearly the intention of Parliament. Also, contrasting the stance of Malaysia, the position of Canada on this issue can be reflected in Section 163 of the Criminal Code of Canada. The case of R against Meshulak, the defendant is found guilty of possessing child pornography on both his home computer and on various storage devices he kept at home, which is contrary to the said provision of the code. These images were not crude drawings, but very realistic computer-generated persons, where many of the images involved underage children. It had been held by the learned judge that child pornography is particularly pernicious, and the fact that the images were animated and did not contain real persons does, although somewhat reduce its harmfulness, it certainly does not eliminate its abhorrent nature. Furthermore, the United Nations Convention on the Rights of the Child, also known as the CRC, provides a baseline international legal standard for the protection of children from sexual exploitation. Article 34 of the Convention prohibits the degrading treatment of children, explicitly requiring countries to take all appropriate national, bilateral, and multilateral measures to prevent the inducement or coercion of a child to engage in any unlawful sexual activity and the exploitative use of children in pornographic performances and materials. Considering this, it will not be outlandish for Malaysia to include animated cartoon characters depicting underage children performing sexual acts into the definition of child pornography, as the animated characters represent the underage children. Furthermore, in the case of R against Sharp, it is stated that possession of child pornography increases the risk of child abuse. It introduces the risk whereby child pornography can be used to groom children. The court found the evidence in this regard to be clear and uncontradicted, and that the legality in possessing child pornography makes it easily available for the would-be possessor to obtain. The issue on child grooming will be further elaborated by my groupmate Angela.
Moving on to the offense of child grooming. Grooming is commonly described as the tactics used by child sex offenders in their efforts to sexually abuse children. Grooming is conceptualized as a range of actions performed by the offender, which begins from targeting the victim, gaining the victim's trust, feeling a need, isolating the child, sexualizing the relationship, and maintaining control. It is a process whereby a child is befriended in the attempt to gain the child's confidence and trust. In Malaysia, Part 3 of the SOACA governs and provides for the offences relating to child grooming, whereas under the UK's jurisdiction, child grooming is covered under Section 15 and Section 15A of the Sexual Offences Act 2003, which hereinafter will be known as SOA. Under the Malaysian law, Section 11 of the SOACA expressly states that the communication content of the perpetrator must be sexual in nature, whereas such requirement is not expressly found in the SOA. The UK law merely emphasizes on the perpetrator's intention, in which the communication must be done for the purpose to obtain sexual gratification. Having said that, the nature of the communication need not be unpleasant, and as long as there exists a purpose to procure sexual desire with the child, it may already amount to child grooming under the UK's jurisdiction. Clearly, the SOA provides a more adequate protection in exposing the reality of an offending behavior, as offenders may not necessarily start off a conversation intimately with the targeted victim. Offenders usually approach the victim in a befriending manner to lower the victim's guard whilst disguising his intention to elicit a sexual response. According to Section 15A, subsection 1, subsection B of the SOA, it is an offence for the perpetrator to encourage a minor to sexually communicate with him or with another person. However, this position is unclear in the Malaysia jurisdiction. So, does it mean that if the perpetrator merely facilitates communication between the child and the other person, he would not be found guilty for child grooming? It is criticized that the lacuna in this area of the Malaysian law would only be filled if the SOACA made clear as to whom the communication may be made to. To further evaluate the adequacy of SOACA, we now turn to the Singaporean jurisdiction to facilitate the said discussion. Under the Singaporean jurisdiction, the provision which governs child grooming is found under Section 376E of the Singaporean Penal Code. Being the only express provision governing child grooming, it should be noted that Section 376E does not reference the possible means of communication as compared to Section 11 of the SOACA, which covers communication by any means under the Malaysia law. In other words, the Singapore law does not expressly provide for online grooming. As we all know, the internet is the most common platform for online offenders as a means to contact and exploit children today. This is because online predators are able to stay virtually anonymous, which makes it easier to approach minors and difficult for law enforcement agencies to identify them. Hence, it is submitted that the Malaysian law is at a fairly better stance as it entails regulations of offending behaviors online. Moreover, following the wordings in Section 376E of the Singapore Penal Code, grooming without the intention to meet the child is not criminalized under the said provision. This can be very dangerous, as children may be exposed to chances of being sexually abused psychologically, which will leave them traumatized. The damage that can be done to a child through online grooming, even without the taking place of a physical meeting, can be significant and should not be underestimated. Thus, the protection offered by the Malaysian position in this context is said to be more adequate and broad as it tackles child grooming in all forms, be it online or offline. This is evident as child grooming itself is already an offence under Section 12 of the SOACA, despite there being any physical meeting. In the event where physical meeting has been arranged or taken place, the Malaysian law further addresses it under Section 13 of the SOACA.
Now, moving on to a more controversial part on sexual offences are marriages when one of the parties have not yet reached the age of majority. This is commonly referred to as child marriages. The SOACA is a piece of legislation designed to counter and protect individuals under the age of 18 from sexual offences. However, as provided by the Law Reform Marriage and Divorce Act 1976, the legal age of marriage for both men and women is 18 years old, while parental consent for marriage is required under Section 12 of the Act if the children are below the ages of 21. With that being said, the Act does, however, permit for females between the age of 16 and 18 to be married with the consent of the Chief Minister. This is clearly stipulated under Section 10 of the Act. Now, it is pertinent to note that Malaysia practices a dual parallel legal system. Therefore, the LRA only governs non-Muslim citizens in Malaysia. Issues pertaining to marriages of Muslim citizens fall under Sharia law. Turning to the Islamic Family Law Act 1984, which governs Muslim marriages, the legal age of marriage under Section 8 of the Act is 18 for men and 16 for women. However, Section 8 goes on further to say that marriages where the woman is under 16 is permitted provided the Sharia judge provides his consent in writing. Thus, it is quite clear from the above two acts that child marriages are legal in Malaysia. The only difference is that civil law has a cutoff age of 16 and in Sharia law, there is no cutoff date. According to Ranggita de Silva de Awes, in an article titled Child Marriage and the Law, published by UNICEF, there is empirical evidence that girls that marry early are often exposed to, amongst all, sexual abuse, sexual violence, and sexual exploitation. One of the recent cases of child marriage that sparked controversy and debate in Malaysia happened in 2018, when a 41-year-old Muslim man took the 11-year-old daughter of an impoverished employee as his third wife. In light of the above, it is unfortunate that the SOACA is silent on the issue of child marriages and the potential sex offences that come along with it. The statute is well equipped with many procedures to combat sexual crime against children, including setting up a special court for child sexual offences and introducing new offences against children, such as child grooming and child pornography, as mentioned earlier. However, as mentioned earlier, the Act does not touch on child marriages. Assaulting or sexually touching a child is illegal, but when the parties are married, touching or even having a sexual relationship does not fall within any crime under the SOACA. And even though having sexual intercourse with a girl under 16 years old is an offence of statutory rape under Section 375 of the Penal Code, child marriage can bypass the law as the exception to this provision, which exempts sexual intercourse between a man with his wife as rape. Therefore, even if a girl in child marriage does not consent to her husband engaging in the act of copulation with her, the Penal Code provides no ground to allege rape at all. This glaring loophole has gone unplugged in the SOACA. Having said the above, calls have been made to include provisions on child marriages in SOACA, and this has also been opined by Dr. Mustafa Shyamalo, a senior law lecturer from Islamic Science University of Malaysia, in his article titled Include Child Marriages under Sexual Offences Act. Now, turning to other jurisdictions on this issue, in England and Wales, the age of majority is 18 as provided by the Children's Act year 2000. However, the legal age to consent to sexual activity is 16, and according to the Sexual Offences Act 2003, a person only commits sexual offences against a child if the person is under the age of 16. This corresponds to the legal age to marry in the United Kingdom, which is 16. By way of comparison, the Sexual Offences Act in UK only recognises marriages involving parties over the age of 16 and criminalises any sexual activity involving persons under the age of 16. The SOAKA in Malaysia has their hands tied when the defense of marriage is invoked regardless of the age of the victim. Although the law in UK provides for marriage of a minor, it does not, however, allow marriage to be used as an excuse to evade all criminal liability, as there is a blanket provision under the Sexual Offences Act which criminalizes any sexual act done towards a child under 16 years old. Now, in India, a progressive step was made when the Prohibition of Child Marriage Act year 2006 was enacted, placing the statutory requirement for marriage in India at 21 for men and 18 for women. The law in India regarding sexual offences against children in a child marriage has since been solidified by a case that went before the Indian Supreme Court. The Supreme Court of India on 11th of October ruled that sexual intercourse or sexual acts by a man and his minor wife would amount to rape for the purposes of Section 375 of the Indian Penal Code. The court has read down exceptions 2 to Section 375, which reads, sexual intercourse or sexual acts by a man with his own wife, the wife not being below 15 years of age, is no rape, to hold that sexual activity with a minor would constitute rape, and the above exception would not be applicable in cases where the wife is between the ages of 15 to 18. Therefore, the law is very clear on this point, and in comparison to the position in Malaysia, it is seen as a remarkable progress.
SOAKA coming into effect, it does indeed counter against sexual offences against children. However, it has created some unresolved issues, particularly in the area relating to the evidence of child witnesses. We argue that the law has mistakenly created two concurrent yet completely opposite evidential regimes applicable to child witnesses in this country, that is, the general regime under the Evidence Act 1950 and the new regime put in place by the new law of SOAKA. Presently, the law relating to child witnesses is governed by two sections of the Evidence Act, namely Section 118 and 113A. This act was operated very much in the same way as Section 118 of the Indian Evidence Act. The phrase tender years is not defined in either the Evidence Act nor the Indian Evidence Act. However, the Indian courts recognize the sole test in determining the intellectual capacity of a child to give rational answers to be his testimonial capacity. In plain words, the competency of a child is to give evidence stems from his ability to understand the questions put to him and to give rational answers, and not from his age. It is the trial judge's role to first test the child witness's competency by asking questions and assessing whether the child is capable of giving intelligible testimony before the child is allowed to testify. Therefore, the phrase tender years must be assessed on a case-to-case basis. For example, the case of Tihal Singh and others against the state of Punjab illustrates that a 13-year-old boy who went into work in the fields and who essentially did a man's work was mature. He was therefore not considered to be of tender years. The major change brought about by Section 133A of the Malaysian Evidence Act was that unsworn testimony of a child must now, as a matter of law, be corroborated. And we stress to add that this is irrespective of how convincing or believable the testimony of the child may be. At this point, it is submitted that Section 133A of the Evidence Act positively affected the rules regarding admissibility of child testimony. This section is based on the antiquated and erroneous notions of the frailty of children in giving reliable evidence. Thus, SOAKA is a good start to abolish the stringent and absurd evidentiary rules applicable to children. Research also indicates that by the age of 3 or 4, most children do understand the difference between truth and lies, although they may have difficulty articulating a definition, as do many of us adults. Children at 5 or 6 may also consider they know the meaning of the terms such as truth, lie, and promise, but their definitions may be slightly different from adults, which may influence assessments of children's willingness or ability to tell the truth. The reality is that there is no evidence to support the proposition that children spontaneously, without prompting, fabricate claims of sexual abuse. Researchers agree that young children can often recall events flawlessly, and this was a study concluded by the Australian Law Reform Commission. Now, while SOACA is indeed a step in the right direction, its scope of application is very low. There's no rational basis for having a distinction between child witnesses in sexual offences cases on one side and all the other cases on the other. Thus, from the above illustration, it is clear to see that SOACA's definition is indeed wider, but its application is limited and narrowed by the Evidence Act. Thus, illustrations in SOACA should be more relied upon in cases of evidence in child witnesses, in all cases.
Moving on to the mandatory duty of reporting, a duty to report is considered as the first step to protect child from sexual offences. Many studies show that mandatory reporting of child sexual abuse can reduce cases regarding to this matter. USA, Sweden, and Denmark have also adopted the mandatory reporting system. The purpose of Section 19 of the SOACA is to ensure the safety of the children, and every Malaysian has the responsibility to prevent children from any forms of sexual activity. Despite Section 19 imposes duties on fellow Malaysians to prevent matters regarding sexual offences being committed to children, the law is still vague and uncertain. Firstly, Section 20 does not specify the minimum age for the reporter, thus creating the issue of uncertainty on the eligibility of the reporter. Besides, there are certain reporting procedure needs to be followed in order for a report to be successful. The law needs to define the types and degree of the offence that attract the duty to report as a basis for one to report, which unfortunately the current law is lack of as being drafted too general. Whereas in South Africa, the law clearly states that the duty to report arises when one has the knowledge of the sexual assault being committed against children. It is crucial for the law to prescribe a clear foundation before imposing a legal duty on every citizen. For instance, the failure to disclose offence under the law of Australia, State of Victoria, requires one to report if he has the information that leads him to form a reasonable belief that a sexual offence has been committed against a child. Following on, Section 20 also does not indicate when should the report be made. It should be noted that the report should be made as soon as possible. Only then tragedies can be prevented, as the police forces are able to execute the job accordingly with efficiency. Another flaw in Section 20 of the SOACA is that there is no exemption being provided to those who has reasonable justification for not reporting, such as the issue of safety being threatened. The case of State and Walden of North Carolina expressly justified the legal principle that one should not put his own life in danger to save others. There are various factors of not reporting child sexual offences, such as the disbelief and unwillingness of the public stigma, threat, fear of negative consequences. The loopholes on the legislation cause reluctance for the public to report on cases regarding child sexual offences. Taking into account of the factors stated, the law needs to indicate some protections for the person who makes the reports, as the fear of inaccurate report will subject to the reporters being sued by the victim's family. Thus, two important things to be considered for the protection of the reporters are an immunity from any legal liability arising from a report which is made in good faith, and a guarantee of confidentiality of the reporter's identity. However, in Malaysia, the law on the duty of report is so far silent about this provision. This can be done by stipulating that a person who is in good faith makes report to the police shall not be liable to any civil or criminal proceedings by reason of making such report. This shield may act as a motivational factor for the citizens to play their part in protecting children. Till then, only the mandatory law reporting system can be truly working efficiently and effectively.
In conclusion, the areas mentioned above are in no way exhaustive and is not able to clearly depict the entirety of the Act. Hence, the statement, the SOACA, though with its flaws, is creditable and praiseworthy, seems to clearly reflect the Act. Lastly, thank you for watching this video. We hope you liked it.